Question 1. Nicole, a real estate licensee, works for Pegasus Real Estate Brokers. Last weekend, Nicole hosted an open house at a vendor's home, which is an activity that is within Nicole's normal course of employment. Which of the following occurrences from last weekend could Pegasus Real Estate Brokers most likely be held vicariously liable for? 1. Nicole was driving home after the open house and spilled hot coffee on herself, which resulted in the destruction of her favorite suit. 2. On her lunch break, Nicole drove to a local cafe from the open house to grab herself lunch. On her drive to the cafe, she was not paying attention to the road and crashed into another vehicle. 3. During a house tour within Nicole's ordinary course of employment, Nicole noticed a banana peel on the floor of the house and did not remove it. A potential purchaser slipped on the banana peel and was injured. 4. During a house tour within Nicole's ordinary course of employment, Nicole tripped down the stairs and suffered a head injury, which resulted in Nicole being unable to work for 4 months. Option 3 is correct because a real estate brokerage will be held vicariously liable for the negligent or other wrongful acts of its licensees when those acts are committed in the ordinary course of employment. In this scenario, Nicole breached her duty of care to the potential purchaser by not removing the banana peel while conducting a tour within the ordinary course of her employment. Because this resulted in injury, Pegasus will likely be held vicariously liable. Options 1 and 2 are incorrect because Nicole's negligence occurred outside of her ordinary course of employment with Pegasus. Option 4 is incorrect because there was no injury suffered to a third party as a result of Nicole's wrongful actions. This means that Pegasus is not vicariously liable. However, they may be liable in other ways, given Nicole has suffered an injury within the scope of their employment. Question 2. When asked for an opinion, which of the following actions would not be likely to relieve a licensee of liability for negligent misrepresentation? 1. When asked for an opinion, a licensee refuses to give advice or an opinion on the subject matter. 2. When asked for an opinion, a licensee gives an opinion that they believe is correct in order to encourage a rapid sale. 3. When asked for an opinion, a licensee gives an opinion with a clear qualification that they accept no responsibility for the accuracy or reliability of the opinion. 4. When asked for an opinion, a licensee directs the person asking for an opinion to someone who is a subject matter expert. Correct answer 2. Option 2 is correct because a licensee giving an opinion, without clearly qualifying that they accept no responsibility for the accuracy or reliability of the advice, could be liable for negligent misrepresentation if the opinion if incorrect. Option 1 is incorrect because refusing to give an opinion would result in no opinion or advice given, which means the licensee could not have made any negligent misrepresentations. Option 3 is incorrect because a licensee giving advice or an opinion with a clear qualification that they accept no responsibility for the accuracy or reliability of the information could relieve the licensee of liability for negligent misrepresentation. Option 4 is incorrect because a licensee directing a person to an expert would not constitute negligent misrepresentation, as no representation was made by the licensee. Question 3. Sandra attended an open house held by Adele, the listing representative, at a lovely Tudor-style home. Sandra loved the house, but the price was at the very limit of her budget, so she wanted to be certain there would be no major repairs necessary to the house. She explained her concerns to Adele, who immediately said, "Don't worry, this house is as solid as the Rock of Gibraltar. It is in A1 mechanical shape." 6 months after Sandra bought the house, the foundation on one side collapsed, involving $15,000 worth of repairs to make the house habitable. Which of the following statements are true? Adele cannot be liable to Sandra because Adele was the agent of the vendor and not the agent of the purchaser. Adele's comments to Sandra involved opinions and not statements of fact, and therefore no liability for negligent misrepresentation can be imposed on Adele. On the basis of the facts in this problem, Adele may very likely be liable to Sandra for negligent misrepresentation. If Adele had told Sandra that she should not rely on Adele's opinion because Adele did not have knowledge of the condition of the house, then Sandra could not hold Adele liable for negligent misrepresentation. Correct answer 2. Adele can be liable in tort to the purchaser because she has a duty not to misrepresent the condition of the house or property. This duty exists in tort law and as well as under the real estate rules. Both Adele and the vendor may be liable to the purchaser. The vendor is vicariously liable for any wrongful actions of the agent, and the agent is personally liable for their own wrongdoings. If Adele's comments may be regarded as expert, she is liable to the purchaser for inaccurate statements of opinion as well as of fact, unless she qualifies her statement with a disclaimer as in option D. Question 4. Which of the following statements regarding fiduciary duties is true? 1. The overarching duty for any fiduciary is the duty to obey their client's instructions, which involves following and obeying all instructions from their client, regardless of what they ask. 2. The law created fiduciary duties to ensure that principals do not abuse their position of power in relation to their agents. 3. When a principal alleges that an agent has breached their fiduciary duties, the law requires the agent to provide evidence to support the fact that they have properly fulfilled their fiduciary duties. 4. Should a licensee face an allegation that they have breached their fiduciary duties, claiming that their actions are in line with industry practices will always result in a successful defense. Correct answer 3, option 3, is correct because fiduciary duties are unique in that when a principal alleges that an agent has breached their fiduciary duties, rather than requiring the principal prove this allegation, the law instead requires the agent to provide evidence to support the fact that they properly discharged or fulfilled their fiduciary duties. Option 1 is incorrect because the overarching fiduciary duty is the duty of loyalty. Additionally, an agent does not need to obey all of their principal's instructions, only their lawful instructions. Option 2 is incorrect because the law created fiduciary duties to ensure that agents do not abuse their position in relation to their principals, not the other way around. Option 4 is incorrect because compliance with industry standards is not a valid excuse for failing to carry out one's fiduciary duties. Question 5. Eli was anxious to sell his house because he knew it was badly infested with termites. Sydney expressed an interest in buying the property after inspecting it, but before making an offer, she asked Eli whether there were any problems she should know about. Eli, elated at the thought of getting the termite-infested home off his hands, assured Sydney that the structure was sound and free of any defects. Sydney subsequently bought the house and within 1 month discovered that the damage caused by the termites had seriously threatened its structural soundness, requiring thousands of dollars worth of repair work. Which of the following statements is true? 1. Sydney can sue Eli under both tort and contract law. 2. Eli cannot be held liable for his misrepresentation because he is not a professional real estate licensee. 3. As there was no special relationship between Eli and Sydney giving rise to a duty of care, Eli cannot be held liable. 4. Sydney's remedies are limited to those provided for under contract law. Correct answer 1, option 1 is correct because as the injured party, Sydney may seek a remedy in both tort and contract law. In the case of deceit or fraudulent misrepresentation, a person does not need to be an expert to be liable. Since negligence is not an issue on these facts, the lack of a special relationship giving rise to a duty of care is irrelevant. Question 6. Interested in constructing a piano hall of fame, Schroeder inspected a 10-acre piece of property which was listed for sale by the owner. After looking over the property, he sought the advice of his friend Lucy, who was a real estate licensee. Lucy stated that the area would be an excellent location for a tourist attraction, but advised Schroeder not to rely on her opinion, as she was unsure about the development restrictions applicable in the area. Without checking any further into the matter, Schroeder promptly bought the property for the express purpose of building the Hall of Fame. He subsequently learned that the land was located in an agricultural land freeze area and could not be developed for the purpose of a tourist attraction. Which of the following statements is true? 1. Lucy owed no duty of care to Schroeder because she was only giving advice as a friend. 2. Lucy's qualification of her statement effectively released her from any liability. 3. Schroeder can reasonably sue Lucy for negligent misrepresentation because she had a duty as a professional in the area to take all reasonable care that the information she supplied to him was correct. 4. Schroeder cannot sue Lucy for negligent misrepresentation because there was no contractual relationship between them. Correct answer 2. Option 2 is correct because where a skilled person gives advice in the course of their business to a person who is reasonably going to rely on that advice, a special relationship giving rise to a duty of care will be created. Accordingly, the skilled person will be liable for any negligent misrepresentation unless the advice or opinion was given with a clear qualification that they accepted no responsibility for the accuracy or reliability of the advice. In this case, Lucy's rendering of advice as a licensee gave rise to a duty of care towards Schroeder. However, since she clearly qualified that statement, he will not be able to sue her for negligent misrepresentation. Question 7. Licensees have been found to be negligent in which of the following situations? A licensee does not verify information in the listing agreement. A licensee fails to conduct a title search of the listed property. A licensee fails to recommend to the purchaser that the purchaser insert a subject to financing clause in an offer to purchase. A licensee fails to disclose material facts to the vendor about the purchaser's ability to buy the property. Correct answer 4. Option 4 is correct because licensees have been found negligent in all of the listed situations. Question 8. Which of the following scenarios would require a licensee to identify a person under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act? A licensee receives funds from an unidentified person who is represented by another licensee. A licensee receives 4 separate $5,000 payments of cash within 12 hours from a single unidentified person. A licensee is representing an unidentified person when a purchase of real estate occurs. A licensee receives funds from an unidentified person in the form of a bank draft. Correct answer 3. Option 3 is correct because the licensees in scenarios B, C, and D are all required to identify someone. As part of a licensee's Know Your Client obligations under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, there are 4 main triggers that require a licensee to identify a party in a real estate transaction. A licensee must identify their client if they receive funds from a person in any form. For that reason, the licensees in scenarios B and D must identify a person. Scenario B also falls within the large cash transaction trigger for identifying a person. Additionally, licensees must identify their client when a purchase and sale of real estate occurs, meaning that the licensee in Scenario C must identify a person. Scenario A does not require a licensee to identify the unidentified party because each licensee needs only to identify their own client. Question 9. Indicate which of the following disciplinary actions might occur when a real estate licensee has breached a provision of the Real Estate Services Act, the regulations, the Home Buyer Rescission Period Regulation, or rules, or has breached the Code of Ethics and Standards of Business Practice. The licensee may be required to pay the costs of any hearing of the Real Estate Board. Their license may be canceled by the British Columbia Financial Services Authority. The Real Estate Board of which the licensee is a member may expel the licensee from the board. The Real Estate Board of which the licensee is a member may suspend his or her license. Correct answer 2. Option 2 is correct because a licensee may be disciplined by having their license suspended or canceled by the British Columbia Financial Services Authority. The real estate boards do not have this power, but may impose a range of other penalties, including expelling the licensee from the board and requiring the licensee to pay the costs of any hearing. Question 10. Which of the following is true with respect to money laundering through real estate transactions? 1. The only way to launder money is through buying physical property with physical cash. 2. Real estate is highly attractive for money launderers because real estate is a fairly stable asset. 3. The use of a corporate entity guarantees that money laundering is not happening, as beneficial ownership is publicly recorded at the Land Title Act Registry. 4. Money laundering is best dealt with by banks and other financial institutions. Correct answer 2. Option 2 is correct because one of the many reasons which real estate is attractive for money launderers is that real estate is a fairly secure and stable asset that cannot be stolen and is less susceptible to dramatic decreases in value in the long term. Option 1 is incorrect because most money laundering is done through electronic means, not through physical cash. Option 3 is incorrect because the use of a corporate entity is commonly used to launder money, as these entities mask the beneficial ownership of property. While the Land Ownership Transparency Act has been enacted to help fight the hidden ownership of land in BC, this does not mean that money launderers have automatically stopped using corporate entities in their money laundering schemes. Further, beneficial ownership is recorded in the Land Owner Transparency Registry, which is different than the Land Title Act registry. Option 4 is incorrect because licensees often have useful insight into money laundering, given their role as boots on the ground. Question 11. Which of the following is true with respect to suspicious transactions under the Proceeds of Crime Money Laundering and Terrorist Financing Act? 1. The threshold for reporting a suspicious transaction is reasonable grounds to believe. 2. Suspicious transaction reports must be filed within 30 days of meeting the threshold for the filing of a suspicious transaction report. 3. Suspicious transaction reports must be submitted electronically to the British Columbia Financial Services Authority. 4. Potential red flags that could initiate suspicion or indicate that something may be unusual without reasonable explanation are known as money laundering terrorist financing (MLTF) indicators. Correct answer 4. Option 4 is correct because it is a true statement. MLTF indicators are potential red flags that could initiate suspicion or indicate that something may be unusual without reasonable explanation. Option 1 is incorrect because the threshold for reporting a suspicious transaction is reasonable grounds to suspect. Option 2 is incorrect because suspicious transaction reports must be filed as soon as practicable after meeting the threshold for the filing of a suspicious transaction report. Option 3 is incorrect because suspicious transaction reports must be submitted electronically to FinTrack. UBC Real Estate Exam Assignment Questions. Chapter 3. Question 12. Carmela has an absolute hatred for visible electric service wires. She is only willing to live in a house that has underground service wiring. She goes to an open house being held by Beatrice and tells Beatrice that she likes the house very much, but is quite disturbed by the electrical wires, which are particularly visible from the family room and kitchen windows. Beatrice informs Carmela that the city encourages homeowners to move their wires underground as part of its beautification project by paying half the cost, and that the charges to Carmela would therefore be minimal. Carmela buys the house and is horrified when she learns from the city clerk that the entire cost of burying the wires must be borne by her and that the cost could exceed $5,000. Which of the following statements is true? 1. Carmela has no right to sue Beatrice because she was only giving her opinion and did not tell Carmela that she could rely on it. 2. If Beatrice made her statement to Carmela knowing that it was false, then she would be liable for damages for deceit. 3. For a special relationship giving rise to a duty of care to exist, it is necessary for there to be a contractual relationship between the parties. 4. All of the above statements are true. Correct answer. 2. Option 2 is correct because it is a true statement. To prove the tort of negligent misrepresentation, a special relationship must be shown to have existed between the person giving advice and the person receiving advice, which is the case between Carmela and Beatrice. There is no need for a contract between the persons in order for such a special relationship to exist. A person relying on the opinion of an expert does not need express permission to do so. Question 13. Mary, a real estate licensee, is acting for a corporation called Real Estate Company, Inc. in a real estate transaction. Mark and Jane sit on the board of Real Estate Company, Inc. Clara owns 20% of Real Estate Company, Inc.'s shares. Holding Company A owns 80% of Real Estate Company, Inc.'s shares. Holding Company A is owned by two people, Jill and Alex. Alex owns 30% of Holding Company A, and Jill owns 70% of Holding Company A. Who in this scenario is considered a beneficial owner of Real Estate Company, Inc.? Mark and Jane, Clara, Jill, Alex. Correct. Answer. Jill. Explanation. Clara owns 20% of Real Estate Company Inc. directly. This is direct ownership, not beneficial ownership. Mark and Jane are board members and have no ownership in Real Estate Company Inc. Holding Company A owns 80% of Real Estate Company Inc. Jill owns 70% of Holding Company A. She indirectly controls 70% of 80%, which equals 56% of Real Estate Company Inc. Alex owns 30% of Holding Company A. He indirectly controls 30% of 80%, which equals 24% of Real Estate Company Inc. However, beneficial ownership typically refers to individuals with substantial control. Jill owns a controlling majority, 70% of Holding Company A, and by extension, has controlling interest over Real Estate Company Inc. Alex's minority stake, 24%, does not grant him significant control. Question 14. Which of the following statements regarding a licensee's reporting obligations under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act is true? 1. If a licensee receives over $5,000 or more in cash in a single transaction, or multiple payments of cash that add up to $5,000 or more in a 24-hour period, the licensee must file a large cash transaction report within 15 days of the transaction. 2. A terrorist property report must be filed within 1 year of a transaction where a licensee believes that property under their control is owned by a terrorist group. 3. Even if the monetary amount is small, licensees have an obligation to fill out suspicious transaction reports as soon as practically possible when they determine that there are reasonable grounds to suspect that a transaction is related to money laundering. 4. A hunch that money laundering is occurring on its own meets the threshold of reasonable grounds to suspect, which is required to file a suspicious transaction report. Correct answer, 3. Option 3 is correct because there is no monetary threshold for reporting on a suspicious transaction, and licensees have an obligation to fill out a suspicious transaction report as soon as practicable when they determine that there are reasonable grounds to suspect that a transaction or attempted transaction is related to the commission or attempted commission of a money laundering or terrorist financing offense. Option 1 is incorrect because the threshold amount of money is $10,000, not $5,000. Option 2 is incorrect because a terrorist property report must be filed without delay by a licensee when the licensee knows or has reason to believe that property in their possession or under their control is either owned or controlled by a terrorist group. Option 4 is incorrect because reasonable grounds to suspect is a step above a simple suspicion or hunch. A simple suspicion or hunch by itself is not enough to amount to reasonable grounds to suspect. Question 15. Jonathan is a real estate licensee working in Vancouver. When representing his client in a sale of property, he began a discussion with Kara, who is a prospective purchaser currently living in Ontario. Kara indicated to Jonathan that she needed to purchase a new house quickly, as her new job in Vancouver starts in a week. Kara had some concerns about the property and asked Jonathan some questions about the property. In response to Kara's questions, Jonathan stated that the property was free of any charges or interests on the property and had no tenants. Jonathan knew that there was a 1-year unregistered residential tenancy in the property, but chose not to tell Kara about it because he thought she would back out of the transaction if she knew about the tenancy. After purchasing the property, Kara would likely sue Jonathan for 1. Deceit, 2. Innocent misrepresentation, 3. Negligent misrepresentation. Mutual mistake. Correct answer 1. Option 1 is correct because deceit is defined as a fraudulent or deceptive misrepresentation used by one person to deceive or trick another person ignorant of the true facts. In this case, Jonathan knew of the unregistered lease and intentionally did not tell Kara, taking advantage of her rush to buy a property. Options 2 and 3 are incorrect because Jonathan knowingly lied about true facts. Option 4 is incorrect because mutual mistake is a contractual doctrine which would not apply in this scenario. Jim recently lost his job and is finding it difficult to make the mortgage payments on his house. As a result, Jim decides to sell the home and hires the services of Carol, a real estate licensee. In an effort to make his Burnaby house more attractive, Jim immediately starts to repair the fence which surrounds his yard. Jim is not the most organized handyman and often leaves tools, boards, and scrap material around the fence. One night, Carol arrives with John and Sarah Middleton, a newly married couple looking for a reasonably priced home. After looking at the house, the Middletons indicate to Jim that they are very interested in Jim's house and that they would like to return to discuss matters further in the morning when they can see what the house looks like in daylight. As John and Sarah leave the yard and walk down the sidewalk to their car, Sarah steps on a board full of nails and injures herself. Which of the following is not necessary to establish Jim's liability to Sarah in negligence? 1. Jim did not take the care that a reasonable person would have taken in the circumstances. 2. It is reasonably foreseeable that a person might step on the board full of nails and suffer injury. 3. Sarah's actions represented a reasonable use of the sidewalk. 4. Jim owed Sarah a duty to take care. Correct answer. 3. Option 3 is correct because in the tort of negligence, the plaintiff must prove that the defendant owed the plaintiff a duty of care, that the defendant breached the standard of care, and that the damages suffered by the plaintiff as a result of the defendant's breach were not too remote in law. It is not necessary to prove that the plaintiff's actions represented a reasonable use of the location where the tort occurred. Question 17. Which of the following statements regarding money laundering is false? 1. Money laundering is the process used to disguise the source of money earned from criminal activity, and most of it occurs through electronic, non-cash transactions. 2. It was estimated that over $7.4 billion was laundered in British Columbia in 2018. 3. Money laundering often has the negative effect of decreasing real estate prices, which cuts down on real estate licensee commissions. 4. Money laundering can have the effect of eroding the public trust of professionals who assist money launderers, such as real estate professionals. Correct answer 3. Option 3 is correct. False, because money laundering has not resulted in a decrease in real estate prices in the British Columbia real estate market. Option 1 is incorrect. True, because money laundering is the process used to disguise the source of money earned from criminal activities, and is commonly done through the financial system electronically. Option 2 is incorrect. True, because it was estimated that $7.4 billion was laundered in British Columbia in 2018. Option 4 is incorrect. True, because money launder has the effect of eroding public confidence and trust in professionals who assist money launderers. Question 18. Which of the following definitions best describes reasonable grounds to suspect? 1. A suspicion that money laundering is occurring that a licensee has formed based on an assessment of facts, context, and indicators. 2. A licensee has a simple suspicion of a money laundering offense. The licensee cannot articulate why they have this suspicion, but this specific licensee usually has good suspicions. 3. A licensee has reasonable grounds to believe a money laundering offense is occurring and can point to verified facts that show a probability of money laundering. 4. A licensee believes that there is a possibility that a money laundering offense is occurring, yet cannot point to any reasons for their belief. Correct answer. 1. Option 1 is correct, because reasonable grounds to suspect occurs when a suspicion has been formed that money laundering is occurring, based on an assessment of facts, context, and indicators. Option 2 is incorrect, because a hunch or simple suspicion is not enough to ground reasonable grounds. Being unable to articulate reasons for a suspicion is a sign of only having a simple suspicion and nothing more. Option 3 is incorrect because it describes the threshold of reasonable grounds to believe, which is a higher threshold than reasonable grounds to suspect. Option 4 is incorrect because if a licensee cannot point to any reasons for believing that money laundering is occurring, then they only have a simple suspicion, not reasonable grounds to suspect. Question 19. Larry licensee entered a listing agreement with Vera vendor and subsequently obtained an offer for Vera's property from Paulina purchaser. Delighted to find a buyer so soon, Vera immediately accepted the offer. 1 week before the date of completion, Terry Takeover approached Larry with an offer to buy the property from Paulina at a higher price. Paulina accepted Terry's offer, and Larry, without informing Vera, arranged the resale once the original transaction closed. Vera has just found out about these dealings and is refusing to pay Larry his commission. Which of the following statements are true? Larry can successfully sue Vera for his commission because he satisfied his obligation under the listing agreement by selling the property. Larry was obligated to inform Vera of Terry's offer. If Larry brings a court action against Vera, he will have the burden of proving that he fulfilled his duties under the listing agreement and under common law. In no situation would Larry be able to receive 2 commissions from the consecutive sale of the same property without breaching the Real Estate Services Act. Correct answer. 3. Larry's obligations to his vendor include the duty of utmost good faith to Vera. This fiduciary duty was breached when he failed to inform Vera of Terry's offer and instead negotiated the resale of the property after completion. In a court action, the onus would be upon Larry to prove that the duty of utmost good faith was fulfilled. With full disclosure to and agreement of all parties, a licensee can properly receive 2 commissions from 2 consecutive sales of the same property. For these reasons, option 3 is correct. Question 20. Harry licensee worked for real estate brokerage A. During the ordinary course of Harry's employment, Harry was hosting an open house with the goal of selling a piece of property belonging to Hermione. During Harry's lunch break, he decided to go to a local restaurant. He used his own truck to drive to the restaurant, but on the drive there, he caused a collision. Which of the following individuals are most likely to be found liable for the accident? Harry Real Estate Brokerage A. Hermione. Correct answer. Option 3 is correct because only answer A, Harry, is correct. Harry would be held liable in this accident as he was the one who caused the accident. Harry's actions were outside the ordinary course of his employment, as he was getting lunch at the time of the accident. Real Estate Brokerage A would not be found vicariously liable because Harry's wrongful act occurred outside the ordinary course of employment. Hermione would not be liable because she had nothing to do with Harry's wrongful act.